Good morning, everybody, and thanks a lot for the opportunity to be here. It's really a pleasure for me. At another conference in Prague just a few weeks ago, there was a colleague from Hungary, and he introduced his presentation that his presentation will be very Hungarian. It will be short and spicy, and I would like to have being here in Budapest, a Hungarian presentation as well. I wanted to concentrate on the topic of the constitutional identity in the Czech jurisprudence of the Constitutional Court, which is quite difficult because the court itself does not use this term. Interestingly, it referred to it only twice in the almost 30 years of existence. One in a bizarre reference to constitutional identity of Lebanon, which is not much relevant for what we are discussing here. And for the second time, it only mentioned this term without really defining it, without telling what it means, and even more interestingly, even without explaining why it resorted to this term. I will come to this only instance later. At the same time, the legal theory became slowly but growingly more and more obsessed with this term. Starting with the Treaty of Lisbon, there was a growing number of articles trying to identify what is this specifically Czech constitutional identity. What is it that the Constitutional Court is about to protect? And as I will show you, maybe similarly to what we have right now heard in the German experience, there is not much specifically Czech in that concept. In the Czech jurisprudence, as I told you, the term constitutional identity is not used. Instead of it, the courts and the theory talks about the core of the constitution, the material core of it, which is defined in the legal text by two articles. The first one, the very first article of the Constitution, claiming what are the basic principles which guarantee, the identity of the Czech Republic, and the eternity clause, quite similar to what we again know from the German experience. By the way, Czech constitutional law and the case law of the court of the Constitutional Court is very much inspired by the German one. So it's lucky for me to speak directly after the German presentation, because I may refer to it quite a lot. As you can see, the eternity clause is narrower than the definition of the principles, which sparked many questions. Why? Whether the other principles are less important than those two ones, but the Constitutional Court relatively early concluded that whatever is written there, all of it is covered by the constitutional clause. So nothing surprising. What may be surprising, and this would be something slightly specific, the Czech Constitutional Court, from the relatively beginning of its existence, was determined to protect this core of the Constitution, this identity, and by some researchers it was named one of the most activist courts in the world in this regard. The first case of this was a case from the beginning of this century, when the Czech constitution was amended in order to prepare the constitutional order for the accession to the EU, and among others, the provision defining the position of international treaties in the Czech legal order was amended. Before this amendment, there was a special, a special place for international treaties on human rights, which were basically put on the highest legal power above the laws, and the other international laws were not mentioned. And by this amendment, the special position of the human rights treaties was abolished, and there is currently only a general provision on the international treaties, and the Constitutional Court declared in this judgment that such an amendment of the Constitution would be against the eternity clause and the core of the Constitution, and it is willing to retain the interpretation as before, that the international treaties on human rights are part of Czech constitutional order, which was quite heavily discussed and still is discussed in Czech constitutional discourse, because arguably, the Czech Constitutional Court has limitlessly expanded the Czech constitutional legal order, incorporating into it all the international treaties on human rights, current and possibly future, which makes the constitutional identity very, very hazy. The second case when the Czech court intervened in order to protect the core of the constitution was maybe even more surprising. It concerned a specific constitutional law concerning elections. In 2008, there was again a governmental crisis in the Czech Republic. The government lost majority in the parliament, and all the politicians decided that they will give up and they will call for new elections. And for some reason, they had not dissolved the parliament, but they adopted a specific constitutional law shortening the electoral term. This sounds a bit strange, but it has been done before in the 90s, so there was a precedent for this. And I underline it was a constitutional law on the electoral term. And still the Constitutional Court intervened again and said, well, this would be again against the core of the Constitution, against the principle of law-abiding state. It will be against the prohibition of retroactive application of laws, and this constitutional law is unconstitutional. Which was again one of the most famous judgments of the Constitutional Court, finding that constitutional law is not constitutional. Again, I guess this goes into the general legal theory, because as far as I know, again in Germany, this was discussed and maybe barked about, but not actually bitten. But our court has done that. And finally, coming now to the relationship, I will try to talk softer. Maybe it will be easier. Finally, coming to the relationship between the Czech constitutional law and the EU one, in the very first ruling concerning the EU law, which, by the way, was quite a minor, relatively easy case concerning one governmental regulation. The Constitutional Court came with an enormous ruling covering all the theory of the interaction between constitutional law and the EU law. It's really like it reads like a textbook. Everything you want to know about it is in this one judgment. Even though it's it's like obiter dictum. It's 100 pages of obiter dictum and 5 pages on the merit, but still it is there. And in this judgment, the Czech Constitutional Court again, I would say, took the Solange doctrine of the German Constitutional Court and said, well, I will bark in every case before me. I will make sure that the EU law does not infringe the core of the constitution. So, with this introduction, with this willingness of the Constitutional Court to protect the Czech identity, were there any cases when it actually did? And in this context, and this very very loud context of the preparation, surprisingly there are no. On the conversely, the Czech Competition Court is thought to be very Europe friendly. It interprets the Czech constitution in all the cases but one in a very pro-European way. One of the most famous examples is the debate concerning the European arrest warrant, discussed throughout the EU, I guess, where many constitutional courts had problem with that, with this constitutionality, and some member states needed to amend the constitution, but the Czech Constitutional Court said, well, the Czech Republic is a member of the EU. Out of it stem some obligations, and if the Czech Constitution may be interpreted in a way which would honor these obligations, if we can interpret it in a Euro-friendly way, let's do it. We have to do it like that. So. Even though this was a complicated case, no biting, and actually even though absolutely no barking. It was just, well, we fully support the Euro-friendly interpretation. Similarly, in the series of rulings concerning the Lisbon Treaty, you definitely remember that the Czech president was very strongly against the Lisbon Treaty. He kept refusing to signing it into force for a long time, and we had a series of questions sent to the Constitutional Court to interpret the Lisbon Treaty, to declare that it is or it is not in line with the Czech constitution. So again, there's a wealth of knowledge in these judgments, and again, the Constitutional Court said, well, the Czech constitution may be interpreted in line with the EU law, and thus the Lisbon Treaty does not infringe this core of constitution. Even though the democracy may be limited by being exercised on two levels, direct elections to national authorities and to EU1, it's fine. Even though the sovereignty is maybe limited by this conferral on the EU, that's fine. We are living no longer in the old ages of the state sovereignty. We need to understand it now in a new way as a pooled sovereignty exercised jointly by the EU. So again, the court was very EU friendly. So there was only one case when the Czech Constitutional Court was decidedly against EU, the case of so-called Slovak pensions, which I discussed a lot at the workshop a few weeks ago. So I don't want to go into details, but this was the only case, only situation when the Constitutional Court declared that it will not abide by the rulings of the Court of Justice, and they decided against what was declared by the Court of Justice. As I explained last time, the motivation behind this ruling was more a domestic quarrel between the Constitutional Court and the Supreme Administrative Court than a protection of some specific Czech constitutional identity. The Czech Constitutional Court, in this case, mentioned this. This was the only non-Lebanese case when constitutional identity was mentioned by the Court of Justice. It mentioned that the Court of Justice should have taken the Czech constitutional identity into account, but did not explain in more detail what it means by that, and what would that have meant if the Court of Justice did consider the Czech constitutional identity, and it closed, as I explained to you last time. It closed the case as a ultra vires declaration of the Court of Justice. And as I explained last time, this is really believed to be a huge exception from the general trend of the Czech Constitutional Court. So, if the Czech Constitutional Court is that much aligned with the EU law, may there be something specifically Czech in the Czech constitutional identity? Well, the only thing discussed in the Czech jurisprudence and in Czech academia is a very old decision you see from the 90s, before the EU case. So it's basically not covered by this research, but still worth mentioning, concerning the so-called Beneš decrets, which definitely in this region are well known. The decision of the then president of Czechoslovakia after the end of the Second World War to confiscate assets of German and Hungarian nationals in the Czech Republic, which after the revolution in the 1989 was repeatedly challenged as being against the fundamental rights as understood today, and about against the principle of prohibition of collective guilt. There were absolutely no individual decisions. It was a decision to confiscate all of the assets. And here, in a rare example, of being of stressing something specifically Czech, maybe the Constitutional Court declared that we cannot assess the legality or constitutionality of events more than half a century ago in today's standards. That it was adopted in a certain context, and this context, and this might be the important part. This context, this experience, is part of the identity enshrined in the Constitution. Interesting case, really defining for the Czech constitutional order, probably outside of the scope of what we are discussing here, but definitely worth mentioning. Which leads me to a conclusion, not very revealing, because even though the Czech constitutional identity is currently discussed, and the Constitutional Court has an idea what it is, and it is really willing to protect it. It declares it repeatedly. It barks all the time. The actual risk of conflict with EU law, this clash of of courts, is quite improbable in Czechia, given the fact that in all the major judgments of the Constitutional Court throughout the last 20 years, 10 years, the Constitutional Court was very pro-European and always interpreted the Czech constitution in line with the EU one. So probably there will be even less biting in Czechia than in Germany. Thank you.